Thank you so much, Lamise.
Thank you.
We appreciate you having us speak to the group today. Before we start, because this is a recorded event, there are a couple of, because lawyers are involved, of course, disclaimers at the beginning. And that is that the information provided today is for general information purposes. It's not intended to be legal advice about a specific issue, or I should say a specific set of circumstances. And we are not creating an attorney-client relationship today. The information today is also based on information that's currently available. And so we want to caution, especially folks who might watch this in the future, that laws and regulations and the application of laws and regulations to particular facts and situations certainly does tend to change over time. And so if you are evaluating a set of circumstances, you should be sure to speak to counsel about your particular situation and the state of the law at that time. So with that, I'll introduce myself first and then turn it over to Brendan. As Lamise said, my name is Anne Marie Cleary. I am an experienced commercial litigator. I help clients solve complex commercial disputes so that they can get back to doing what it is that they do, what they prefer to do, which I'm sure is their business. And I have been practicing law for more than 25 years, and I use that experience across a wide array of subjects areas to advise and advocate for my clients. In the employment law arena, I advise employers on compliance with federal, state, and local laws and defend them when their businesses are threatened by claims. I am really passionate about helping people navigate the ever-changing arena of employment law and regulations, and to help them mitigate risk and end litigation as quickly as possible. Brendan?
Thanks, Anne Marie. Thank you, Lamise, and everyone for being here. We appreciate it. As lawyers, the only way to learn a new topic is to do something like this. And so it's great to kind of force us to really dive deeply into something. It's better to do it like this than to have a client who does something wrong and learn it, in the context of a case. So this has been a great experience, and we appreciate it. I'm also an attorney here at Eckert Siemens. I primarily do commercial litigation and employment work, similar to Anne Marie. I was previously a Navy JAG, and I'm still in the Navy Reserve, so I do a lot of military work and military law as well. But Anne Marie and I, other attorneys here, we work with a lot of Virginia businesses, businesses outside of Virginia too, just with compliance work, making sure that they're not running afoul of any of the laws and things that we're going to be talking about today. And then when they do, unfortunately, helping them through the litigation process as well. So thanks again for having us here, and we're looking forward to it. And important question, can everyone see my shared screen? Anne Marie, can you see the PowerPoint? And Lamise, are we looking good?
Yeah, we're good, yes.
Okay, we're good to go. So we are going to kick this thing off and get into this exciting topic. Anne Marie?
Okay, thank you, Brendan. So just by way of introduction, I'm sure all of you are aware of the many areas in which AI is used in employment, applicant tracking and hiring systems. A lot of employers will use AI to track employee performance, which then may feed into consideration for promotions and learning opportunities and things like that. HR information systems, of course, and overall integrated systems. So as we all know, AI has come into very broad use in the last few years, in not just the employment arena, but also in finance and lending. Banks often use it for risk assessment on loan applications. Healthcare uses it for resource allocation, especially, for example, with the pandemic. During the pandemic, a lot of AI was used to assess the application of resources, scarce resources, so for the best outcomes. healthcare, it said healthcare and insurance. I came across a case recently. Actually, the fast food industry has used AI. McDonald's apparently used a voice-powered technology to record customers at the drive-through. The objective was to improve individual customers' experience in the drive-through. And so they recorded customer voices and used their system to identify repeat customers, which I don't know about the rest of you. To me, that sounds a little creepy. That actually is illegal in Illinois. And so a customer of McDonald's sued the company. And I believe that case is still ongoing. So we'll have to get back to you about how that works out. But this area is getting a lot of attention, especially from federal agencies and also from some states and localities. And as you know, the EEOC recently issued some guidance that suggests that employers may be responsible for non-compliance with federal discrimination statutes in the hiring process. And so I think that technology vendors can expect customers, employers, to be a little more involved in understanding this technology going forward in order to protect themselves and to remain compliant with federal, state, and local laws. Brendan?
Sure. So what we're going to talk about now is just a little bit of the backdrop of, what is the legal framework that is out there right now that employers and companies need to consider when they're assessing, whether to use technology and how to use it. So from a federal law perspective, these are the laws that apply similarly to every single state in the country. There's a variety of anti-discrimination laws that I'm sure you've come across, and they're the ones that we deal with every single day. Title VII of the Civil Rights Act, which creates a number of protected categories that employers can't use to discriminate, such as sex, race. There's other sections of the Civil Rights Act that create additional protected categories, such as national origin. There's a Pregnancy Discrimination Act, the Age Discrimination and Employment Act, Americans with Disabilities Act. There's protections for discrimination based on genetic information. So there's a whole bunch of what are called protected categories. And employers can't use those protected categories in making employment decisions. Otherwise, it is discrimination and they can get sued. And also, these laws create retaliation provisions and numerous other causes of action. And so there's several different federal agencies that oversee these laws and enforce these laws and issue regulations and guidance interpreting these laws. The EEOC is primarily the main agency when it comes to employment discrimination. They have oversight over the federal government workers as well as private employees who work for private companies. And the EEOC oversees Title VII claims, the Pregnancy Discrimination Act, Age Discrimination Act, as well as the FMLA. So there's a number, the Equal Pay Act, there's a number of different federal anti-discrimination suits that have to go to the EEOC first as an administrative charge. And again, the EEOC will then issue guidance about what those laws mean. The Department of Justice actually, it's not just a criminal agency, it also is involved in regulating and enforcing certain civil laws, specifically for local and state government workers. So if a state or local government worker were to have a discrimination charge, that would be brought through the Department of Justice. So they also sometimes issue guidance on these different laws. And finally, the FTC isn't really an employment entity. They oversee and enforce consumer protection laws. But one of those laws is the Fair Credit Reporting Act, the FCRA. And that act actually does have a provision in it that impacts employment. I kind of refer to it as like the background check law, where if an employer is making decisions about someone's employment using third-party information from an outside source, a third-party entity, then there's specific notice requirements and consent requirements that must be given to the employee before that action can be taken. So again, that most commonly comes up with background checks, but it could be implicated here if whatever the automated technology being used goes out and gets information. So this is just a quick overview, but there's a lot of different laws to consider. And what happened recently, as Anne-Marie said, is that the EEOC and actually the DOJ as well, they put out guidance talking about how the issue of automated employment systems and AI fits into some of these laws, mainly ADA, which protects disability. So we'll talk about that guidance here in a second.
So some of the ways that automation might, well, let me back up. I think the idea of using AI in hiring initially was, at least in part, hey, if we take the human out of this, the subjective human element out of this analysis, we're going to cut way down on discrimination. So there's not going to be a human being looking at a resume and saying, oh, that name sounds like that's a person of color, or or that there's a gap in the resume, that's probably a woman with small children, that sort of thing. And so great idea. The problem is that no system is perfect, and some things, it appears that some discriminatory elements can be incorporated into these programs. And so a program that is into which discriminatory data has been fed, for example, it can perpetuate the problem in analyzing resumes. So for example, if an algorithm gives points for a degree from a highly rated university, that might have an adverse impact on folks graduating from historically Black colleges and universities, which are not do not tend to be ranked among the Harvards and the Yales and universities like that. And so that's the sort of that's kind of the way that automation can result in some unintended results in the analysis. And Brendan, why don't you tell us about Amazon's experience, because they thought they had it really figured out a few years back and discovered otherwise.
Right. So one of the most well-known examples of this did happen at Amazon. And I'm sure as all of you know, I mean, Amazon is on the forefront of developing technologies in many different areas. And kind of what their business model is they develop something for use internally, and then it becomes so good that it then can potentially become a product that they actually sell. Like, for instance, they have their own internal Zoom type product that, at some point may be so good that it, will become a competitor of Zoom or Microsoft Teams. And so what they were using is they developed a algorithm to find qualified candidates to be software developers. And what they did is they used data from the 10 preceding years of people who applied and became successful Amazon software and program developers in the preceding 10 years. And they fed that data into the algorithm, and then they set certain inputs that the algorithm was going to measure. And the idea is that the AI basically makes an educated guess about who's going to be a successful software developer. And so when someone applies, they run that resume through this algorithm, and the output is, this score of how well they think they're going to be doing at Amazon. So the problem that they ran into is the technology field is overwhelmingly disproportionately male. So what they did was they taught their AI that the best software developer has a resume that trends male, and that men are better software developers than women. So they created a really effective technology for screening out female software developers. And then the second mistake that they made was in the audit feedback phase, they didn't do a very good job of monitoring what the output was. So one of the huge important things for anyone using AI to ensure that they're not running afoul of laws, which we'll talk more about at the end, is you have to be militant about the auditing of the output and really assessing it. Because at the end of the day, if you have a disproportionate output that favors one group of people over a protected category, like men over women, like Caucasian people over Black people, then you have created a discriminatory process. So Amazon, they put bad data into it. It perpetuated their own implicit biases, and they did a poor job of auditing it. So that project has been scrapped, but that's a really good way to think about how to screw this up, even for some of the smartest scientists in the world. So the EEOC has been focused on this issue for several years. The use of algorithms and automation in employment is certainly an issue that a lot of more progressive politicians are very focused on as something that needs to be regulated. That's a big risk of causing discrimination and hurting certain disenfranchised communities of people. So from that political lens, the EEOC they established an exploratory committee to discuss, what the guidance should be. And then this past May, they finally issued their guidance. Interestingly, the guidance only applies to how software, algorithms, and artificial intelligence apply under the ADA. So it is focused 100% on disability. Obviously, those other laws, Age Discrimination Act, Title VII, race, gender, age. I mean, again, if you have an AI system that discriminates based on those other protected categories, you can be violating those other laws as well. And the EEOC hasn't issued guidance on those things. And Anne-Marie and I were discussing it. And I think it's because it's so obvious that, if you have a tool that screens out women, you're discriminating against, whereas the disability issues are a little bit more complex. But the first thing that the guidance does, and any company that is going to be using any type of automation tool to assess applicants or employees absolutely should read this. It's very practical, and it's kind of like a how-to of not to run afoul of the ADA. So it's certainly very helpful. But they define kind of the scope of this as applying to software, algorithms, and artificial intelligence. And so they have definitions within there, but software is just simply a program that has a function. An algorithm is the formula that software uses to achieve the function. So, a simple example would be a resume screening software where you could input words like the word manage. If the word manage is not in the resume, then that resume gets put at the bottom of the pile or scored lower. So, that would be a simple software example that uses a very simple algorithm. And then we get into the artificial intelligence realm when the algorithm itself can adapt, and the algorithm can it gets such a high volume of data being put into it, and it becomes so sophisticated that basically the artificial intelligence is making educated guesses about things, as opposed to just a if this, then that kind of simple computer programming function. It gets into the actually, making judgment calls seemingly. And again, it has the ability to change and adapt its own algorithm over time to hopefully get more accurate outputs. So that's kind of the world. Again, if there's a technology that assesses an employee or an applicant, then that could potentially fall under the purview of this. And then, of course, if the actual employment decision, like denying the resume, denying the application, terminating somebody, if that is actually made by a computer, not a person, then that certainly would be automated and fall within the purview of this. So the guidance, talks about the different ways that the ADA might be violated by using these technologies. The first is that there's no accommodation process. So the Americans with Disabilities Act requires that employers have a reasonable accommodation process. So if anyone in America has a disability, which is a medical or a psychiatric condition that affects a major aspect of their life, and that condition makes it so that they can't do the essential functions of the job, then the ADA says that if that person comes to the employer has to have a back and forth conversation with that person about what are the alternatives. So, if simple example, if someone's in a wheelchair and there's steps, then, an accommodation would be to put in a ramp. Or if somebody, has frequent migraines that are very, very severe, an accommodation could be a flexible work schedule or working from home. So employers need to engage in that back and forth. And then at the end of the day, if the accommodation is so unreasonable that it creates an undue hardship, then the employer may not have to do it. So the first way that a company can run afoul of the ADA is if that accommodation process isn't clearly communicated to the applicant or the employee, or if it doesn't exist at all. I mean, if the computer is just making automatic decisions and the person is denied, and part of what the computer is measuring may be because of the disability, then you've skipped that whole requirement of the accommodation process. So that's number one, is you have to think about that. Emery, do you want to say something?
I was gonna point out that this is kind of like I think everybody on the call recalls about, I'm probably dating myself, 10 or 15 years ago, when companies stopped taking paper applications and started taking everything online. And employers needed to put up a number or a method for somebody who was unable to complete an online application to submit their information so that they could be considered for the job. So for example, somebody who's visually challenged and their assistive reading technology was not, or the employer's website was not compatible with their technology that would read the website to them so that they could complete the form. So this is, and the EEOC was very careful in this guidance to say, folks, this is nothing new. This is nothing new. We're just applying the same old ADA principles to some new technology. And so their focus has been on making sure that applicants have an even playing field when applying for jobs that they are able to, the essential functions of which they are able to perform with or without a reasonable accommodation. So, if a test has to do with speed, keyboard speed, and somebody has a mobility disability, there needs to be an alternative so that they have an opportunity to demonstrate that they can still perform the essential functions of the job. Brendan?
Yep. And so the other two ways to violate the ADA that the EEOC talks about, the second one we've already talked a lot about. I mean, if at the end of the day, the output of whatever the process is that you have in place disproportionately screens out people with disabilities, then you may inadvertently be discriminating. It may have a disparate impact on people with disabilities. So that could, of course, present a problem and be the basis for a claim against the company. And then the third one is the ADA does protect employees from certain inquiries about medical conditions from their employers. And basically, employers are really only allowed to ask somebody questions about whether or not they can do the functions of the job. They can't ask questions that will elicit information about a disability. So again, if you're automating these functions, there's certain things that, if it's a chat bot that's interfacing with somebody, some type of game that they're playing to measure aptitude, again, the employer just needs to be aware of, that issue of, is this technology that we're putting in place asking somebody something that's going to elicit information about a disability, that could also run afoul of this. So the EEOC does go through what they call promising practices. We'll talk about that at the very end, but they do walk through a couple different hypotheticals and examples and talk about the types of things that employers can do to not run afoul of the ADA, which is very helpful. And then, as we said, the DOJ also at the same time issued guidance on the same topic. It's much shorter, but it basically says the same thing. But again, just if you are looking into this, that's another resource.
Okay, so there are, in addition to federal laws, there are some current state and local laws that govern this area. Illinois, I believe, was the first one, and their law regulates the use of artificial intelligence to analyze video interviews. And so some of you may be familiar with programs like HireView, where the prospective employee is asked a series of questions, their responses are recorded, and then either the employer can review the videos manually, or the program can review and score them, and the programs review and score on things like eyes and the tips for HireView say don't smile too much, and make sure you look at the right place on the, look right at the camera, not at your screen, and things like that. And so under Illinois' law, applicants need to be advised in advance that the tool is going to be used, and they have to consent. And the employer has to explain what it is they're scoring on these interviews. And this provides the applicant an opportunity to ask for reasonable accommodation if there's some reason why the interview would not score the way that it is designed to score. Interestingly, Illinois' law also limits the distribution of the recorded interviews. So as you see on the screen, an applicant can request an employer destroy all copies of the interview, but the statute and the employer must comply within 30 days, but the statute also limits the number of people that can look at it. So if you do a recorded interview and you wonder, oh my gosh, that was awful, I'm sure they're passing it around that place and laughing at, that under Illinois law, that, is not something that should be happening. It's limited to those whose expertise or technology is needed to evaluate the applicant. And it applies to jobs based in Illinois. Though based in is not defined in the Act, so there's a little ambiguity there, and it remains to be seen how that plays out in terms of enforcement. Maryland also has a law that prohibits the use of the technology unless the applicant signs a consent in advance. The law is very basic. It also delineates what needs to be in the consent. New York City recently passed, and it will take effect January 1 of 2023, probably the broadest in the country. It prohibits the use of automated employment decision tools unless the tools are annually audited. The results of the audit are posted on the employer's website, and requires 10 days advance notice to the applicants, which, if you think about it, really slows down the employment process. Nobody's hiring anybody quickly in New York City. And New York City's statute ordinance, though, the audit is for impact based on race, ethnicity, or sex. So not as broad as some of the federal statutes, but nevertheless, requires the annual audit and the posting, and the act, the ordinance applies to employees living in New York City. So before we move on to some proposed state laws that are out there, I do want to point out that there's also you need to be aware that there's an intersection in some states between the use of AI in employment and employees or applicants' privacy rights under privacy acts that different states have enacted. So a lot of states have enacted laws that say you can't ask an employee for their password so that you can look at their Facebook page, and you can't ask about salary history, and you can't, get in deep into their social media. You can't require them to show you their social media pages. And so a lot of states out there, you have to be aware of what their data privacy security laws also say if they apply to employees or prospective employees. So California, for example, has a very broad data privacy law, and it arguably applies to employees and applicants for employment. On the other hand, or I should say in contrast, Virginia's data privacy law is limited to consumers in the traditional sense. It does not encompass employees or prospective employees. So just be aware that there's that intersection between with this AI issue and some state data privacy laws. Brendan?
Sure, thanks, Anne-Marie. So, one of the important things just kind of contextually to think about is, as more and more employees are working remote, employers need to think about the state and local laws where those employees work. Those almost exclusively are the laws that will apply to that person's employment. So it becomes really complicated, and we run up against it all the time, where small companies even have 10 different employees in 6 different states. And so the idea of them producing an employee handbook, has to comply with the most onerous requirements of every single one of those states. And so this as these new kind of piecemeal laws in different states and municipalities are starting to come out. If there's a company that uses this technology nationwide, they need to be cognizant of all these laws, which is really, really hard to do. So some of the laws that are on the books have been proposed. There, as many as 16 different states have had, some type of algorithm employment law that was proposed. There really are 3 that actually went far enough, I think, to get to like the committee stage. None of them are enacted. I'm not going to go through the individual, every single element of each one just for time. But New York, California, and DC, the themes are that there needs to be advanced disclosure of what the technology is, and also annual auditing of the technology is required in all 3 of the laws that are proposed. So again, from kind of an ADA perspective, what the states are doing is, they view this as, the employee needs to know what the technology is and how it's used in order to be able to ask for an accommodation if they need one. And so the big concern with these laws is private causes of action. So if an employer doesn't have the audit done, or if the audit isn't published publicly, if that's what's required, or if there's notices or consents that are required from the employee under the new laws, specifically, the one in DC, they can then directly sue the employer for damages, punitive damages, attorney's fees. So this is starting to shape up a lot like website accessibility litigation, which is under Title III of the ADA. And so that's where a visually impaired person who maybe has a screen reader or some type of device to navigate websites, if a website's not compliant with that technology, it could be an ADA violation. And what it's done is it's basically created this entire industry of attorneys who have a visually impaired person just surf the internet and go from site to site to site. And when they come across one that doesn't comply, they'll file a lawsuit. And so for employers now, if you're putting out a web-based application and somebody is sitting in New York City and applies on the internet, then the requirements of that New York City ordinance that went into effect January 1st, or that goes into effect this upcoming January, those apply. And so if you have the wrong notices, if you don't do the 10-day waiting period that's required, I mean, then the employer could be liable. So this could, as these laws get enacted, you could start seeing people in Washington, D.C. Basically surfing through these application processes to find companies that don't have the right disclosures up, that haven't done the audit requirement and things like that. So again, none of these three laws, New York, California, or DC, have been enacted yet. We're certainly not experts, but it seems like California is going to be enacted, some version of it. DC and New York are less certain, but there certainly will be more legislation to follow. So this is what's coming. It's coming that more progressive states and municipalities are going to give people private rights of action to sue if the notices aren't done properly, if the consent is required and isn't done right, or if the annual audit is not done or isn't published correctly. So that's where this is going from kind of a risk management perspective. And very quickly, we had mentioned the FCRA. It kind of has a unique application to employment. But this, again, is just one other thing to think about. If the technology is using information from a third-party source, like if you're getting a background check from a third-party vendor and then using that information to make an employment decision, like deny somebody's employment application, then you could be triggering the FCRA. And the FTC, they've, going back to 2020, issued guidance on the use of AI and algorithms in the consumer financial context. And so, this is definitely something that the FTC is focused on as technologies that potentially subvert the rights of consumers. And so this again can apply to the employment context. And it's just another thing to think about, that if this technology is being used, and if part of the algorithm involves using outside data, credit reports, things like that, then there's a whole series of notices, consent that needs to be gotten, a very formulaic process that employers have to follow. If they don't, then there could be FCRA violations, and you could have some problems with the FTC. So just one more pitfall to just throw on the pile at the very end there. But again, just things to be conscious of, and not to say that this technology shouldn't be used. It's just that there's a lot of things that need to be considered before it is.
So to follow up on Brendan's comment, for example, one of the things to consider when you're evaluating technology is to talk to the vendor about whether or not the technology accommodates required FCRA notices. So if it does import data and evaluate data from a third party, like a credit report, for example, will the technology accommodate the issuance of adverse action notices, which are, as Brendan said, are very formulaic in terms of you must issue it and give somebody an opportunity to respond, and then you can deny or reject their application a certain time after that. So the EEOC sets out in its guidance a number of promising practices, it calls them, and it talks about starting with the right data. So, going back to the Amazon example, maybe thinking carefully about the data that you're importing, making sure your data set is clean, so to speak, and talking again with the vendor about this, and what audit procedures do they have in place? Do they have user testing to validate the technology? Have they, was the tool developed with individuals with disabilities in mind? Is information presented in different formats? And importantly, disclosing how it's used and giving applicants and employees an opportunity to ask for an accommodation in the process. As I mentioned at the beginning, a lot of employers, are, especially with people working remotely, are using performance management technology. How often does your mouse move during the day? But they want to make sure that employees don't turn the computers on and then go watch, The Price is Right or something like that. So, if you're using that kind of technology and feeding it into your algorithm to consider employees for promotion, are you allowing for situations in which a person with a disability is not going to move their mouse as often? Maybe they use, they speak instead of using a mouse, they speak to move the mouse. And so that, how are those worked in? It's certainly be sure to provide a reasonable accommodation when one is requested and legally required. Make sure that you're testing for actual abilities that are necessary to the job, as opposed to testing for abilities from which you infer some further ability that you'd like this person to have in the job. And I wouldn't be an employment lawyer if I didn't say document. Make sure you have a written policy about the use of AI, both in hiring and in relation to your existing employees, about how you're going to use people analytics. That policy, together with record keeping about, how representative is your data set, and the steps you went through with your vendor in creating an algorithm for you to evaluate candidates. That kind of information, that documentation, is going to help you if you find yourself in a position where somebody feels they've not been treated fairly and they want to make a claim. And as always, it's important to train your staff to recognize requests for accommodation. So it's not always, hey, I need an accommodation. It might be, gee, I did really poorly on that test that you had me do for this application. I'd really like to try it again. And then maybe that's an entree to have a discussion, an interactive discussion with the candidate about why they feel they didn't do well and what difference, what you could change that would be different. Maybe it's as simple as giving somebody a little more time to accommodate their disability.
So I'd already mentioned that, any company that is recruiting in different localities, they need to understand the laws that apply in those localities, which is becoming increasingly difficult as the workforce becomes more and more remote. And so companies are hiring people in a variety of different states. We're not just hiring folks within 20 miles of the plant anymore. It's much more different and much more complicated. As we've discussed, employers need to understand the state and even local laws now that apply. If you have a nationwide policy, one way to navigate that as a promising practice is to think about what's the most onerous requirements when you analyze all those different laws, and maybe set your policy to comply with those. A lot of the local and state laws that we discussed, what they're trying to do does make logical sense. And from their perspective, how can a disabled applicant get an accommodation from a process that they don't know exists, or they don't understand what the process is? And so what these legislatures are trying to do is they're trying to say, you need to inform applicants before this starts of what you're using and why, what you're measuring. You need to show them how you've measured people with it in the past. And that gives them the opportunity to say, well, wait a minute, I think, maybe you're not measuring me because of my disability. And so therefore I need an accommodation. So again, just taking a moment to take a breath, to step back, to really think about, what job functions is this technology measuring? Is it potentially measuring things that it shouldn't be measuring? And then if we're going to put this nationwide process in place to mitigate this risk, one strategy is to put the most onerous requirements possible. And then you don't have to worry about any of the state or local laws because you comply with all of them. And then the final piece, I'd already mentioned this, but it really seems like this is setting up to be a lot like the website accessibility for visually impaired people situation, which I know some folks here in Southern California. I mean, California has become just an absolute hotbed of those types of cases. It's just such low-hanging fruit for plaintiffs' counsel. There was one plaintiffs' counsel in particular that we ran up against, and she had filed 500 lawsuits based on website accessibility. I think it was since 2019. And so the way that it works is they would send a demand letter saying, pay us a bunch of money or we're going to sue you. And a lot of those cases get settled. So if she had to go to court 500 times, I mean, that I would imagine she's settling 5 or 10 times as many as that. So extremely, extremely lucrative. And so here, again, unwary companies that are using this technology, if they don't know the state and local laws, because it's the internet, you can have somebody in these locations surfing the internet, applying to these jobs. And there's defenses and things to argue, like they don't have standing, they didn't really intend to apply to the job, but nobody wants to get sued. Nobody wants to talk to us. Nobody wants to pay us, and you shouldn't. And so, again, it's something that, as these new localities and states start passing these laws that have private causes of action, this is going to crop up, and plaintiffs' attorneys are going to get wise to it. And it's just a huge exposure for companies. So, when you're making the decision whether or not to use this technology, that's the types of risks that you need to consider, and the importance of understanding all the different laws that could apply and making sure that you're complying with them.